Welcome to the Deep Dive. Today we're digging into something really crucial in contract law. It's about whether a clause is just a promise or if it's an express condition. Getting this wrong can be, well, disastrous. It can lead to losing the entire deal, what lawyers call forfeiture. So our mission today is to really nail down the criteria courts use to tell the difference, because that distinction changes everything for performance and breach.
That's exactly right. The stakes are incredibly high. You mentioned forfeiture, and that's the key. If it's just a promise, a covenant, you might pay damages if you don't perform, but the contract usually survives. But if it's an express condition precedent, fail that one thing and the other side's duty to perform justly vanishes. Poof, gone. You could lose a fortune over what seems like a technicality. So to see how courts handle this, we'll look at the principles most follow, specifically using a New York Court of Appeals case. It involved a real $350,000 dispute. We're basically going to walk through their exact thinking process step by step.
Okay, let's set the foundation then. When a court starts looking at a contract, what's the basic definition? What exactly is a condition precedent in their eyes?
Well, the black letter rule is pretty clear. A condition precedent is an act or an event, something other than just time passing, that absolutely must happen first, unless it's legally excused, before a duty to perform under the contract even kicks in. Think of it like a gate. That gate has to swing open before the obligation to say, pay money, even exists.
Got it. A gate. Let's test that definition. We're looking at a case called New York Bronze Powder Co. v. Benjamin Acquisition Corp. So Benjamin bought assets from New York Bronze. Part of the price, $350,000, was deferred through a promissory note. Importantly, it was a non-negotiable note. And the key language was in Section 4.2 of that note. It said, the note holder, New York Bronze, shall be required to surrender this note for cancellation upon the maturity or prepayment in full of this note in order to receive payment. Benjamin refused to pay, saying they didn't surrender the note. Okay, let's analyze New York Bronze. First, what are the legally dispositive facts here? What actually happened regarding the failure to surrender the note?
Right. So New York Bronze sued to get paid the $350,000. But in court, they only tried to submit a copy of the note. Their CFO testified the original was being held by their lender, Perpetual Savings Bank. The bank had an interest in the assets, you see. So the crucial fact is New York Bronze did not physically hand over the original note to Benjamin.
Okay, and because they didn't hand it over, what was the core legal issue the Court of Appeals had to decide?
The precise legal question was this. Should that language in Section 4.2 requiring surrender in order to receive payment be read as a strict condition precedent? Meaning, did failure to surrender completely excuse Benjamin from paying? Or was it just a contractual duty, a promise, that New York Bronze breached?
So how does a court decide that? What rule of law did they use? It sounds like the language wasn't crystal clear, so they needed some kind of tiebreaker rule, right?
Exactly. They needed an interpretive rule. And they applied the standard one, which you find in the Restatement of Contracts and most jurisdictions follow. It says that if contract language is doubtful or ambiguous, courts should interpret it as creating a promise, not an express condition. This preference is especially strong when two things are true. First, if finding a condition would cause the obligé, the person owed the duty, here in New York Bronze, to suffer a major forfeiture. And second, if the event in question, surrendering the note, was entirely within that obligé's control. Basically, the law really dislikes interpretations that lead to harsh, disproportionate outcomes if it can avoid them.
That's a powerful bias, then, trying to avoid unfair loss. Okay, let's see how they applied it. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the requirement for explicit conditional language? That phrase, in order to receive payment. What did they make of that?
They found it wasn't explicit enough. It was deemed doubtful. The court pointed out that truly clear conditional language was missing. Language that spells out the consequence of failure. For instance, if it had said something like, upon failure to surrender this note, Benjamin's obligation to pay shall be null and void, well, then it would clearly be a condition. But in order to receive payment, the court felt that phrase was a bit passive about the consequence. It wasn't strong enough to overcome that default legal preference against finding a condition.
Okay, so the language itself was shaky. Did the court look elsewhere in the contract for clues? What about the second element, the context of the overall contract drafting?
Yes, the structure was very important. The court looked at the introductory paragraph of the note. That's where Benjamin's core promise to pay the $350,000 was stated. And that paragraph explicitly said the promise was subject to Sections 2 and 3. Now, Sections 2 and 3 dealt with things like subordination and set off's clear financial conditions. But crucially, the payment promise was not made subject to Section 4.2. The court inferred from this. By specifically listing Sections 2 and 3 as limitations, but not Section 4.2, it suggested the parties intended only Sections 2 and 3 to be conditions. Section 4.2 looked more like just procedural language, covenant.
That's clever. Like saying, if you meant this to be a condition too, you should have put it with the others. Okay, let's get back to that core policy bias. How did the court apply the third element, forfeiture risk, noting the preference against express conditions when the obligee controls the event? New York Bronze losing $350K over paperwork seems like a huge forfeiture.
Absolutely. And this is where that policy really guided the decision. Surrendering the note was something New York Bronze could have done. It was within their control. They just didn't. Now, if the court labeled that failure a condition, the result would be New York Bronze forfeiting the entire $350,000. The court called that a potentially harsh result. Given the ambiguous language and the fact that NY Bronze controlled the event, the court leaned heavily on the rule that prefers interpreting the term as just a duty on NY Bronze, not a condition killing Benjamin's obligation. They wanted to avoid that harsh outcome.
Okay, but I'm still thinking about Benjamin. They wanted the note back for a reason. Presumably to avoid paying twice, right?
Yeah.
Why wasn't that risk important? What was the final crucial policy point regarding the fourth element, the non-negotiability of the note?
You're right. That's usually the reason, protection against double payment. But here, that reason basically evaporated because the note was non-negotiable. That was the game changer. Since it was non-negotiable, anyone else who might have gotten the note from New York Bronze would take it subject to any defenses Benjamin already had against New York Bronze.
Meaning, what does subject to defenses mean practically?
It means if Benjamin had already paid New York Bronze or had another valid reason not to pay, they could use that same defense against any third party trying to collect on the note later. So Benjamin's actual risk of being forced to pay twice was, well, the court called it de minimis, tiny, almost non-existent. Given that minimal risk, the court found it highly unlikely the parties intended such a drastic consequence forfeiture of $350,000 for failing to perform the surrender requirement. The punishment just didn't fit the almost non-existent crime, so to speak.
Right. After analyzing the doubtful language, the contract structure, the huge forfeiture risk versus the tiny policy risk, what was the court's final conclusion?
The court reversed the lower court and sided with New York Bronze. They concluded Section 4.2 created only a covenant or a contractual duty for New York Bronze to surrender the note. Yes, New York Bronze breached that duty by not surrendering it. But that breach was considered minor, procedural. It wasn't substantial enough to excuse Benjamin's core obligation to pay the $350,000. So the judgment for New York Bronze was reinstated. Benjamin had to pay the money. New York Bronze might owe Benjamin some small damages for the inconvenience of not getting the note back, but they didn't lose the main payment.
Wow, that really shows how courts weigh these factors. Let's try a hypothetical to make this condition versus covenant thing really stick. Say I agree to sell you my house for $500,000. The contract says buyer will pay $500,000 provided that seller paints the mailbox safety yellow before closing. If I, the seller, forget to paint the mailbox, is that a condition or a covenant? Do you still have to buy the house?
That's almost certainly going to be interpreted as a covenant. Why? Forfeiture. Think about it. You, the seller, would lose the entire $500,000 sale over a can of yellow paint. That's an incredibly harsh result for a very minor, easily fixable detail. A court would look at that, provided that language, see the massive potential forfeiture, and likely say it's just a promise to paint. The buyer, you, would still have to close on the house, but maybe you could deduct the, $50 cost of painting the mailbox from the price, or sue me for the cost, but the main deal stands.
Okay, that makes sense. But what if I really wanted that mailbox painted yellow? Like, I'm obsessed with safety yellow mailboxes. How could I draft that clause to make absolutely sure it's a condition so if you forget, the whole deal is off?
Now you're thinking like a drafter aiming for certainty. You'd need language that leaves absolutely no doubt about the consequence, something much stronger than provided that.
Yeah.
You'd need to say something like, seller's painting of the mailbox safety yellow prior to the closing date is an express condition precedent to buyer's obligation to close this transaction. If this condition is not strictly satisfied, this agreement shall automatically terminate and be null and void, and buyer shall have no further obligations hereunder. See the difference? That explicitly calls it a condition and spells out the termination consequence. It basically forces the court's hand and overrides that policy preference against forfeiture.
Got it. So the message is, unless the consequence of failure like termination is spelled out with brutal clarity, courts will bend over backwards to avoid forfeiture and call it a promise. Okay, this has been incredibly helpful. So thinking about someone facing a contract issue or maybe studying for an exam, can you boil all this down? Give us an actionable step-by-step checklist for diagnosing whether language is a condition or a covenant.
Absolutely. Here's a practical 4-step framework you can use. Step 1, identify the language. Look for those classic conditional words, if, provided that, on condition that, when, after, subject to. If you see those, it might be a condition, so you need to keep going. Step 2, check for explicit consequences. This is critical. Does the clause explicitly state what happens if the event doesn't occur? Does it say the contract is void or the obligation terminates or uses similar language of discharge? If that explicit consequence language is missing, it's highly likely just a covenant, especially if forfeiture is involved. Step 3, apply the interpretive preference if doubtful. If the language is ambiguous, now you bring the restatement policy. Ask, would finding a condition cause a significant forfeiture? Is the event something the party seeking payment the obligor controls? If yes to both, the strong presumption is it's a covenant. The court will try not to enforce a forfeiture. And step 4, test the policy and materiality. Think about the purpose of the clause. What risk was it meant to address? If that risk is actually minimal or non-existent, like the de minimis risk with the non-negotiable note, it strongly suggests the parties didn't intend a forfeiture for failure. It makes the argument for it being just a covenant much stronger.
Okay, that's a really clear framework. Identify the words, check for the explicit kill switch, apply the anti-forfeiture rule if it's doubtful, and test if the whole thing even matters from a risk perspective. The big takeaway really seems to be how much the law dislikes forfeiture. Unless you use incredibly clear language to force that result, policy often steps in.
Exactly. And that leads to a final thought, maybe something to ponder for anyone drafting contracts. If even seemingly direct language, like in order to receive payment, wasn't enough to create a condition in the New York Bronze case, how careful do you need to be? It really highlights that just implying sequence isn't enough. If you truly need a condition precedent, you have to explicitly state the consequence of its failure that the obligation dies. Otherwise, you risk a court interpreting it as just a promise to avoid a harsh result.